Welcome back to Primetime News. We continue now with reaction to the court's decision on the NIDS Act. Joining us live in studio for that discussion are the President of the Jamaica Bar Association, Emil Leiber, and Executive Director of Jamaicans for Justice, Roger Malcolm. First, let's start with some initial reaction to the decision, beginning with you, Mr. Leiber.
Good evening. Well, it is certainly a very comprehensive decision, numbering over 300 pages. It was a prompt decision. It was well delivered. And I think it comprehensively addressed all the issues that were raised before the court. And in fact, I think they went into an additional issue that was not strictly speaking on the papers. I think it was Section 45 in terms of the constitutionality. So I think anyone who looks at this decision can be very clear as to the basis on which it was decided.
Before we go through those bases, let's your reactions as well, Roger Malcolm.
Certainly, I think this is an example of showing us that there's a cost to not doing things the right way. And it is an example where I think there's a critical mass of public support, but a major division as to how it's implemented. And this is an example of showing that the how matters just as much as the what.
All right. Now, let's now talk about those big issues that the justices spoke of. First big issue, question of privacy. Chief Justice talking about different types of privacy. What did he say?
Well, when the Chief Justice and other judges spoke about privacy, it's in the context of the compulsory nature of the requirements of the Act. That the requirement, that the concept that you are required to submit biometric data to the state, and if you fail to do that, it's a criminal offense. So there was a significant focus on the whole question of in a voluntary concept as versus a compulsory concept, because you can choose to give information to whoever you wish. You do it to your doctor and so on, and for many other purposes, personal address and so on. But this concept that the state can legislate that you have to basically give blood samples, retinal scans, and as you know, other than the usual fingerprinting and so on, is what was, in my view, deemed to be in breach of our privacy rights.
And one of the concerns there would have been the security of this kind of information, Roger Malcolm.
Certainly. And so, I mean, the issues that was raised, and JFJ raised it in July of 2017 in a long letter to the Prime Minister's office, which is now validated, which is that the Section 43 at the time and Section 44 and further on that dealt with the security of the database was insufficient. And the argument that was made was that eventually sometime down the line there'll be a Data Protection Act that should solve the issues. And the response is that, well, that needs to come before you pass the NIDS law. And here I think they're learning the lesson of rushing that without the corresponding protections. And so from our perspective, we don't want to see NIDS die, but we want to see a compliant NIDS. And one element of a compliant NIDS is ensuring that the infrastructure for security is there before we pass a law.
In fact, the Chief Justice himself commenting on that issue by saying that we have to examine what is in front of us. We can't wait to see what happens. Exactly. A significant portion of this surrounds the question of the mandatory nature in relation to the denial of goods and services. What did the justices say there, Roger?
I mean, and so it came down here again to the larger question of if it was proportional to the intention of NIDS, that denying someone public services, making it a crime not to register, was not a justifiable way to implement this law, and it wasn't proportional to the goals of the law. And so the test in law, as a court articulated, is that one, the law must be for a proper reason, and second, even if it's for a proper reason, it can't go beyond what is needed to achieve that reason. And for that and for several other points, the court found that the law went beyond what was demonstrably justified or rational to the aim, and as such struck down the entire law.
In fact, it's a 309-page judgment with each of the justices setting out their setting out the terms or the basis, and the Chief Justice spends a fair amount of time talking about the principle that you're exposing there, Roger, which is this question of needing to change the framework within which we judge, in which we adjudicate on constitutional matters. This question of needing to look at it from the perspective of whether it is justifiable, and therefore the accountability factor, wanting the executive and legislature to be accountable to members, to citizens. Explain what is the fundamental principle there that the court is trying to outline.
in essence, there is a concept that there's a certain basis on which there can be a restriction and limitation of rights. Because once it is that we live in a society, we all compromise to live within a society. But we only should compromise our rights as citizens to the extent necessary for us to live together in a democratic society. So basically, there's not this freedom on Parliament to just pass any legislation that it is so inclined, but you must establish, and if it is challenged by the court, the government has to establish that this abrogation of rights, this what would be a violation of your right to privacy and so on, is necessary for them to govern.
Yes, and so to make sure that's very clear, none of our rights are absolute, but they're legally protected.
Yes.
And so what the Chief Justice and the other justices is saying in this particular case is that once someone proves that their right is likely to be violated or is being violated, then the burden of proof shifts to the state to show that either A, it's not being violated, or that that violation is legal. It's demonstrably justified, it's proportional, it's rational. And what the court is saying is that it's in the provision of those explanations that the government was unpersuasive, and as such they struck down the entire law.
And the Chief Justice says this is a fundamental shift in how we look at these judgments.
Certainly.
From your perspective as someone who works in advocacy, why is it a fundamental shift?
Well, primarily it's a fundamental shift because it's after the 2011 passage of the Charter of Rights, which amended Chapter 3 of our Constitution. And when we brought in place a modern set of constitutional rights, we also deepened the protection of those rights. So before, the bar was much higher. It was almost at the criminal threshold of proving beyond a reasonable doubt. And there was something called a presumption of constitutionality that was a little bit more severe.
That once the government is passing
Yes.
or is putting forward a law, it is doing so in good faith.
Yes.
And
now,
that the court should accept that if there's not, you know, blatant evidence that it's not the case.
Exactly. Now, what the court is saying, or the Charter is saying, is that we have legally protected rights, and one simply needs to show that there is a risk of violation or that they're engaged by some executive action or law, and then the state must then prove either that it's not engaged, that it's exempt for some reason, or that the violation is justified. And they have to come with objective, fact-based arguments to prove that. And as the court found here, there was no objective basis to support many of the arguments that the government was making, sadly.
The Chief Justice saying about that, quote, "It has been raised to the rank of a fundamental constitutional principle and represents," he says, "a global shift from a culture of authority to a culture of justification." What's the road ahead, though? Begin with you, Emily Leiber.
I would say that in the road ahead, when one examines this judgment, that it requires the government to look more closely when it is passing legislation on whether or not this is justifiable. Because this concept of "I need to prove" is not for someone else to disprove it. If this is challenged, I as a government need to prove to the satisfaction of the courts that this is demonstrably justified. So I think that requires a shift in mindset on the legislator when it is enacting legislation.
What specific steps should the government take?
Sure.
The question that the court contemplated, one of the chief questions, was whether to just focus on getting rid of the aspects of the bill or the entire bill. But in this case, the justice decided the entire bill. So what are the steps that the government should take?
So two things. So because the entire law has been struck down, from our perspective, it doesn't need to be the end of an idea to have a national ID card. What it needs to be is the start of conceptualizing that ID system in a legally compliant way. There are many persons, including JFJ, who will support the government to craft a legally compliant and lawful national ID system, because it can bring benefits, but not this way. And then secondly, to what Emile is saying, our lawmakers really should start thinking of the lawmaking process as something that has to conform with these things, not something that says, "We'll pass this law, challenge me if you're bad." And that's kind of been respectfully the attitude that people have gotten when they've raised these issues. I hope this ushers in a paradigm shift that makes the constitutionality at the start of the lawmaking process, not something at the end.
All right, thank you so much. Roger Malcolm of Jamaicans for Justice and Emile Leiber of the Jamaica Bar Association.